Just admit a couple more people. There we are. So as I say, we're going to cover some other substantial reason dismissals today, which seems to be something we're getting some more questions on lately. So I always think it's good to cover, something that there might be a bit of a trend in the queries we're receiving in the breakfast briefings. So it'll be a bit of a whistle-stop tour, but I thought before we go into some other substantial reason, which is a potentially fair reason for dismissing someone, I thought it would be good to first just recap, what is unfair dismissal when we're speaking of it as a legal concept. So what are the kind of tests that a tribunal will look at? What are the legal questions that we'll answer? So we'll recap that very quickly. We'll also then look at, what is SOSR as a concept as well. We'll look at the legislative framework, where it comes from, what it means. And then I think with SOSR, it can cover, a range of different scenarios. So I think it's going to be most helpful to actually look at examples from case law. So I've picked out a good few cases on different situations that we can go through together. So starting off with a recap on unfair dismissal. I promise I'll try and avoid at this time in the morning where possible reading sections of the Employment Rights Act at you, but we'll go through the kind of basics. So the first thing a tribunal will look at is, has there been a dismissal? I think this is always a good one to point out because a dismissal in law is a bit more wide-ranging than the way we might use the word naturally. So you'll see there that one type of legal dismissal is expiry of a limited term, or we would probably more so call it a fixed term contract. So that's quite an interesting one because normally when we think about what dismissal means, we'll probably think about that second bullet point there, which is just a kind of straight termination of the employment contract by the employer. But if a fixed term contract's expiring, that would also constitute a dismissal in law. And the last bullet point, constructive dismissal, hopefully you're all familiar with that concept, but that might be, where an employee's resigned, but they're actually entitled to treat their resignation as a dismissal. And that's because it's been done in response to some sort of fundamental breach by the employer. So we normally see that crop up as a breach of the implied term of trust and confidence. So that renders that resignation a dismissal. And all of that is contained in Section 95 of the Employment Rights Act. And I've actually hyperlinked the legislation if anyone fancies having a look as a bit of homework after today. Later in the Employment Rights Act, after they define what a dismissal is, they say that there's 5 potentially fair reasons you can dismiss someone. And you'll see that a lot of them, the titles naturally kind of show what the definition is. So capability, when someone's not capable to do their role, whether that be through poor performance or ill health, that is a potentially fair reason for dismissal. Conduct, normally off the back of a disciplinary process where someone's breached a disciplinary rule or there's been some sort of misconduct which warrants dismissal, could be potentially fair. Redundancy, again, more self-explanatory. Statutory ban is where it would be unlawful to continue dismissing someone. Good example for that might be, if someone loses the right to work in the UK, you'd then perhaps have to dismiss for statutory ban, because it'd be unlawful for them to carry on working in the organisation. But the last one, which will be the focus of today, is some other substantial reason. And you'll see there, it's not like the others. It's not inherent in the title what that actually is. So I think it's a good one to go through today in more detail, but it is a potentially fair reason for dismissing someone. And I promised not to go through sections of the Employment Rights Act, but this one is important because this is the test that a court or tribunal will use when they're determining whether or not a dismissal is fair or unfair. You'll see it's largely based on the reasonableness of the employer. So that's why, our advice to you quite often might be based on what's reasonable. A couple of important points in the definition, which is in italics. you'll see that it says including the size and administrative resources of the employer's undertaking, which I think is quite an important part as well, because, for example, what's reasonable for a large company with a full HR team, HR business partners, a HR manager, is going to be different from what's reasonable for, you know, an SME whose HR function might be performed by someone, you know, who also takes care of their payroll, their finance. So you can see how they do take the specific business, what resources they have into account when they're deciding if an employer's acted reasonably. And that's in section 98(4) of the Employment Rights Act. So what is SOSR? Because I'm conscious we've not really touched on that yet. It's really designed to be a residual catch-all, potentially fair reason, because you might find yourself in a scenario where there is some sort of substantial reason that employment's become untenable, but it doesn't neatly fit into conduct or capability or redundancy. So SOSR is designed to be there as a potentially fair reason in those scenarios, you know, where when you look at the facts, it doesn't seem to, you know, neatly slot into one of the other fair reasons. There isn't actually a statutory definition of the term. So in the Employment Rights Act, they don't actually go on to explain what is some other substantial reason. And we don't have any sort of statutory guidance document that sits aside the legislation, which goes into detail on the term either. So where we really look to is previous case law. You know, what kind of things have tribunals in the past held or not held to be a substantial reason? But one thing that does come through quite clearly in the case law is that the reason must be substantial. So a lot of the times that can be interpreted as, you know, last resort when you've exhausted other options, not something that's trivial. It needs to be something that really renders employment untenable. And, you know, you need to be able to evidence that. So we'll look at case law where I think that this is a concept will come to light a bit more. So in a tribunal is looking at SOSR dismissals. The first thing that an employer will need to do is that they'll need to be able to prove that the substantial reason they're relying on is the sole or principal reason for the dismissal. So, you know, it's not conduct, it's not capability. They would need to be able to evidence and show during the tribunal that SOSR is the sole or principal reason. And the second part is showing that the decision to dismiss based on that reason was reasonable in all the circumstances. So that might be things, you know, looking at the facts, or looking at the process carried out, all of these types of things. So that is a quick look at what the law is on SOSR, but I think it will be, you know, a bit more apparent when we look at actual examples that have gone through the courts and tribunals. So I've picked out a few different headings and some case and some kind of key takeaways from each. So our first example that we'll go through this morning is third-party pressure, which I think in our industry is particularly relevant. There might be a scenario where you have people in employment, but they solely fulfil their duties on a client or customer site. And this covers that kind of scenario where perhaps they withdraw their consent to have them on the site, or they put pressure on you as the employer to remove that employee from the site. So that might leave you in a situation where there's some question marks over how employment will continue. So this was looked at in the case of Henderson against Connect South Tyneside. And again, I've hyperlinked all these cases as well, so you can go on and have a read at the full judgments if you fancy it. The employer was a contractor and they provided transport services to the local council. And there was an employee who worked on that contract, and he was a bus driver. And his role involved driving disabled children to and from school. There was actually a clause within the contract between the employer and the council that said the council had a right to request to remove someone from the site at any point. So that was there in the background. And the bus driver was subject to historical accusations of child abuse. So there wasn't actually any sort of record of a conviction or a charge or anything material, but they seem to be quite, well-founded and well-spread accusations that this had taken place in the past. Came to the attention of the council and they requested Connect, the employer, to remove him from post, to stop him from driving the buses. He was dismissed for that reason and he claimed unfair dismissal against his employer. This one actually got appealed all the way up to the Court of Appeal, which is quite helpful in terms of case law because it means that we know this is a binding decision. And they actually held that that dismissal was fair by reason of some other substantial reason. And the kind of things that they found compelling when they were deciding reasonableness and fairness was that they had evidence where they could show that before dismissing the employee, they'd actually spoken to the council and tried to change their mind. So, almost put some arguments forth for the employee, tried to come to some sort of arrangement to stop him being removed from the role. Although they didn't work, they were able to show that they took that step before dismissing. And they also carried out a process before dismissing where they got him in, went through alternative work that they had, vacancies that might match his skills. Of course, there weren't any for him, but because they could evidence, we did a process beforehand. We looked at alternative work. The tribunal was happy and the Court of Appeal agreed that it was a fair dismissal. So I think from this one, we can take that, even if you have some sort of third-party pressure or just a straight request that you remove them from site, you want to be doing some sort of process beforehand that factors in, before you even start that process, going to the client, customer, whoever it is you're contracting with, trying to change their mind, so you don't need to start the process with the employee. And where that's unsuccessful, moving on to having some sort of meeting with the employee where you look at alternative work before making that decision to dismiss. And another kind of scenario where SOSR seems to crop up quite often is where you perhaps have personality clashes or a breakdown in relationships within a team. And this one can be quite tricky because it almost sits on the line of misconduct or a disciplinary, but you might have, perhaps you've had situations in the past where it's not even so much that someone's clearly breaking a disciplinary rule or they've did something, it's just that maybe their style or tone or their personality, causes friction or clashes within the team. So there's case law on that where that's been held to be some other substantial reason dismissal. And a good case for this is the case of Perkin against St George's Healthcare NHS Trust. So Mr. Perkin was employed as Director of Finance, so quite a senior role. There wasn't actually any sort of concern about his knowledge or skills or the way he behaved or got on with people within his team. But there were some concerns around his behaviour when he was dealing with senior colleagues, stakeholders, and also external advisors. So a lot of kind of intimidating behaviour, didn't maintain good relationships with these colleagues at all. It was actually a disciplinary process that they started, and the reason they gave for starting that disciplinary process was management style and interpersonal relationship breakdown. And after that process, he was dismissed for conduct, but also incompatibility with his colleagues. So in this case, the tribunal actually looked at the facts and said, they don't find that conduct was the sole reason or the main reason. It was actually SOSR due to a breakdown in relationships. And they said quite a couple of quite helpful things in this case for when employers are dealing with these types of situations. The first one, he says that you can't dismiss for personality itself. So, if someone has quite a difficult or unusual personality, that in of itself isn't enough to dismiss them from the team. But if you're able to demonstrate that as a result of their personality, there's some sort of material breakdown in relationships, that's when it can be a SOSR. And thus they were able to evidence that because of his behaviour, there was actually detrimental impact on the team. So I think they said there was a lack of cohesion, because he was responsible for, reporting on his team to more senior colleagues in the business. So it caused a lack of cohesion, and they were able to evidence operational difficulties. So because of that, the tribunal held that there was enough there to constitute a substantial and sound reason. So had a look at some other case law before today, and some other kind of key points for dealing with these types of situations with personality. Is again coming back to that idea of dismissal being the final option. So a tribunal will generally want to see an employer actually trying to implement and go for action short of dismissal first. So that might be redeployment, whether or not this employee has skills and there's somewhere else in the business that they might be able to go, and move away from those relationship issues. The next, mediation. That one's a bit tricky because obviously you're relying on the people agreeing to participate in the mediation, but I think even being able to evidence that it was put on the table as an option, and being able to evidence, that it wasn't taken up, but raising it. The last one is changing work patterns. So if there's anything you could maybe do with that to stop people working on the same shifts or the same areas. So just trying to think of ways that you could solve the issue without dismissing, because if there were ways that you could solve it without dismissing that you didn't bring up or investigate or look into, then that could have an impact on the fairness of the dismissal. It might be that you look into these things and there's nowhere you can go with them, but I think just raising them and giving an explanation of why you've considered them and it's not appropriate, is still advisable. And the last one is just don't confuse it with misconduct, which I think can be trickier in this one. Employers generally take quite a dim view if someone goes to tribunal. If an employer argues this is SOSR, but it's actually conduct or it's actually performance. The reason they don't tend to like that is arguably there could be a shorter process involved with an SOSR dismissal than, say, going through a full disciplinary process. So what a judge won't, appreciate is if SOSR has been argued, to avoid having gone through a disciplinary process at the time. So I would just make sure, you'd have to be able to evidence that it's because of relationships, whether that's doing a bit of investigation, maybe you'll have statements from people involved, are people refusing to work with this person, or is it just been a clear instance of misconduct? So you have to look at that first. And the last one that I'm going to cover today, which again is quite interesting, and comes up from time to time, is reputational risk. So that's where, perhaps there's been an incident in the public, it could have, a criminal element to it. And for that reason, an employer might opt to dismiss because of the reputational risk. There's only been a few cases that have made it to tribunal on this matter. And generally, it seems to be a kind of harder one to argue, so I thought worth raising. A good case for this is Bosher against EUI Limited. Apologies in advance because the facts of this one aren't very nice at all. But the employee was dismissed because he was charged for possessing indecent images involving children. So upon hearing about this charge, the employer decided to launch a disciplinary process. And the basis of the disciplinary process was the risk of reputational damage to the employer. Ultimately, it was dismissed afterwards, went to the tribunal, and it was held to be an unfair dismissal. And one of the comments that the tribunal kind of made here was that employers should avoid what they call knee-jerk reactions, and actually do a bit of investigation and really analyse what is the reputational risk to our specific business. So in this case, they looked at things like the fact the case was still developing. So he'd only been charged. So at the time he was dismissed, they didn't know if the hearing was going to be held in public. They didn't know if it was going to be picked up, widespread by media. It hadn't gotten to that point yet. They also took regard of the fact that the role he performed didn't involve working with children in any way. So when you're thinking about reputational risk, the reputational risk might not be as expansive in this specific business if he didn't work with children. It's quite an interesting one because it almost feels like when you're looking at this, you might be going against what you think morally. But the way the law works here is that someone will receive their punishment via criminal law. So there's no kind of automatic pathway to dismissal, if you like. You really would need to analyse it. They did give some more guidance on how you should do that balancing act between a knee-jerk reaction. They said, again, they should have looked at, and it's that theme again of it being the last option and exhausting everything else before, because they've said again, they should have looked at redeployment, reducing his responsibilities, or suspending him pending developments in the criminal proceedings. So they said that they should have looked at those steps before opting to dismiss him. I'll say these are all fact specific, so that might have went a different way if perhaps he was in a role that did involve working with children. Obviously that would up the risk of reputational damage, or if it was a bit longer and, say employees, customers had found out there was going to be a real risk of reputational damage to the business. But I think in this case, where it perhaps fell down was that it was done a bit premature before they could really show, this is having a reputational risk, this is causing reputational risk to us, and this is all the evidence to show that. So I appreciate that was a very quick whistle-stop tour of SOSR for this time in the morning. Not many